This is Bloomberg Law with June Grasso from Bloomberg Radio.
The U.S. Supreme Court is the only thing standing between Donald Trump and the sentencing tomorrow on his hush money conviction. Today, New York's highest court refused to block his sentencing. On Wednesday, Trump had asked the Supreme Court to call off the sentencing, but the justices have yet to respond to that request. Joining me is constitutional law expert Michael Dorf, a professor at Cornell Law School. Would it be unprecedented for the Supreme Court to intervene in a state case before sentencing?
No. I mean, there are extraordinary circumstances in which it's possible to obtain a stay from the U.S. Supreme Court before final judgment in the state court proceedings. An example might be if someone is scheduled to be executed and has a plausible claim that the execution would violate their Eighth Amendment rights against cruel and unusual punishment, for example. And even if the state courts haven't finally ruled if the execution is going to proceed, then the court can intervene. There's opportunity for something called certiorari before judgment. This isn't a full-on cert petition, but it is a stay application. So I don't think it would be unprecedented to intervene at this stage. It is an extraordinarily high burden, however, that an applicant must satisfy in order to get this kind of relief.
What are Trump's arguments asking the court to intervene to stop the sentencing?
He basically makes three sorts of arguments. One seems not really well geared to what he's seeking, and that is he says that the trial judge improperly admitted evidence that constitutes official acts in violation of Trump v. United States, which was the immunity ruling. Now, in defense of Judge Merchan, that ruling hadn't come down yet at the time of the New York State trial, but that doesn't matter. As long as the judgment isn't final, you're bound by decisions of the Supreme Court that come out. And so it's possible that that is a good claim on the merits, but that doesn't really justify extraordinary relief. Ordinarily, if you think the trial judge erred, even if they erred only retroactively because the Supreme Court changed the law on them, you have the full proceedings in the state court, and then you go to the Supreme Court. So I don't quite see why they're making that as a claim justifying extraordinary relief. The second thing they say is that in one of these cases where there is a claim of presidential immunity, there is an entitlement to an automatic stay pending the resolution of an appeal on the immunity question. That's a slightly better argument because there the idea would be that this is really about whether you have immunity from criminal trial. If you have an immunity from the trial at all, then you might say, well, you should get everything you're entitled to by way of appeal before the case proceeds any further, because the immunity from trial is not just an immunity against the sentence or conviction, it's immunity against the proceedings itself. And so there's a kind of logic to it, although I should say that the New York response, which was filed earlier today, makes a fairly good point, which is to say that this isn't really about immunity. If you'll recall, in the immunity case in the Supreme Court last term, the Supreme Court basically had three holdings. Holding number one was that the president is absolutely immune for core executive functions. Holding number two is the president is at least presumptively immune for other official acts. And then holding number three was that the president is not immune for unofficial acts, but you can't use official acts as evidence to prove unofficial acts. Here, Trump's argument is that some of the testimony consisted of official acts and therefore shouldn't have been allowed to prove the unofficial acts. And what New York argues in its response is that that piece of the holding from Trump against the United States is not about immunity because it's a rule of evidence, and rules of evidence are necessarily going to be implicated in the course of a trial, not as an immunity to trial in the first place. That brings me to the third argument that Trump makes, and this I think is his best, although it's the most open-ended. And he says simply that in the same way that a sitting president is thought to have immunity against criminal prosecution while president, that immunity should also extend to a president-elect. Now, this is a novel claim, mostly because a president-elect has never been involved as a defendant in a criminal case before. But it's not a crazy argument. And if it's true, I guess you would say, yeah, criminal proceedings have to stop immediately.
This is largely a symbolic sentencing. So dangers that Trump mentions, like the burden on him to have this sentencing when he's preparing for the transition, seem sort of bogus because Judge Merchan said that he's not going to sentence him to any time or any kind of penalty at all. So it seems to me like this is really about the stigma of Trump being the first felon to be sworn in as president of the United States. Do his arguments fail in that respect?
I think so, right? So the argument for why you would extend presidential immunity to a president-elect is that presidential immunity is designed to enable the president to carry out the very important work of the executive branch, which is vested just in the president, according to the unitary executive theory and so forth. And you might say that the presidential transition, which the president-elect supervises, is of an equal stature, and so it should extend. And therefore, a president shouldn't be subject to the kind of distractions that a criminal trial poses. But as you suggest, right, there are no distractions here. If Judge Merchan sentences Trump to unconditional release, as he apparently is planning to do tomorrow, nothing changes. It's not as though he's going to have to go to Rikers Island or something and can't oversee the transition. And so Trump's argument has to be that every president-elect is immune from all criminal proceedings, even if the rationale for that immunity doesn't seem to apply here. So it's a kind of argument that says, here's a rule. I realize that the rule wasn't designed for people like me, but you should announce the rule anyway, and I should get the benefit of that rule.
Trump used the Supreme Court's ruling last year on presidential immunity, and he delayed his sentencing to the point where he's now 11 days away from inauguration. So should he be able to take advantage of his own delay tactics and now say, well, I shouldn't be sentenced at all?
Well, I mean, whether he should be is a different question from whether he will be. I mean, all along, that has been the strategy in all of the criminal cases against Trump, which is that he delays as long as possible. And then, at earlier points, he said things like, well, these cases are politically motivated against me as a candidate for president, even though the only reason that they were getting rolling during the pendency of his candidacy was because he delayed them from starting earlier when he wasn't yet a presidential candidate. So far, the delaying tactics have worked. He's benefited from the delays that he has caused. If he gets this stay from the Supreme Court, then, yeah, he will have been able to benefit from the very delay that he was responsible for. I should say, though, that, in response to your earlier question, it's not entirely clear why anybody cares about this. If Trump is sentenced, right, nothing's going to happen to him. And if he prevails ultimately on his claim that the trial was marred by the introduction of the official act evidence, that will result in the reversal of the conviction. He also has some arguments under New York law for reversing the conviction. The stigma, in other words, would seem to be temporary. And on the other hand, he's already been convicted as a felon. So delaying the sentencing doesn't mean he is not a felon when he takes the oath of office, because any reversal of the conviction, if there is to be one on appeal, is at least weeks, probably months off.
He's facing a court where there are 3 justices he appointed. You talked about that unprecedented immunity decision that saved him from having to go to trial in the federal criminal case over the subversion of the 2020 election. They also banned efforts to strike him from the ballot. So you need 5 justices to grant a stay. How likely is it that they would grant a stay of the sentencing?
I don't, what's the Yogi Berra line? I don't like to make predictions, especially about the future. I don't like to make predictions about this Supreme Court because it's not really my expertise. That you're asking there a question about psychology as much as anything. I don't think the grounds for the stay are very strong, but then I thought the grounds for presidential immunity, in which he won, were not very strong, and he got 6 votes for that, or 5 2/3, depending on how you count Justice Barrett, who didn't agree with everything that the majority did. So I think on the merits, this should be denied, but it wouldn't surprise me if the court granted the stay, and it would also not surprise me if they granted the stay without writing much of an opinion, because they might not want to, try to give reasons here, theory that they could give them later, and then it doesn't matter.
In some sense, is this a test of the justices' willingness to accommodate Trump in his second presidency?
I think it'll be perceived that way, but, as I say, the stakes here are pretty low, and so, the real test of that will be when one of his substantive policies that has very serious implications gets up there. So, for example, if he tries through executive action or, frankly, even through a statute to end birthright citizenship, which is protected by the 14th Amendment, that'll be a test. I think that's a test the Supreme Court is likely to pass because it's just so clear that the Constitution extends birthright citizenship. But some of the other, policies involving detention potentially of undocumented immigrants, involving other sort of forceful executive actions, those I think could be the more important tests.
And he'll have 4 years to test them. As you know, Democrats have questioned the objectivity of Justices Clarence Thomas and Samuel Alito. And Alito revealed in a statement that he spoke by phone this week with Trump about a job candidate for the new administration, but they didn't discuss pending cases or any other Supreme Court matters involving Trump. Are there any ethical problems with that?
I have a fairly idiosyncratic view about these questions of legal ethics. That is, I think that a lot of the things that Justices Thomas and Alito and maybe some other justices have done over the last few years and that we've learned about from some of the ProPublica reporting are highly problematic. I don't really think it makes much difference. That is to say, Justices Thomas and Alito are extremely conservative. Their views are sort of baked in and by their ideology more so than by anything that's going to happen in a conversation. So that it's hard for me to imagine that a conversation between Trump and Alito is going to sway Alito's vote one way or the other. But that's partly because I think that Alito is just inclined to vote in ways that would make Trump happy anyway. I don't think there is a prohibition on a president talking to a justice about something that isn't a matter pending before the court. I mean, a lot of the justices will attend the State of the Union. A personnel matter strikes me as not especially problematic. I think if this were someone other than Justice Alito, any justice other than Alito or maybe Thomas, and if it were a different president, I don't think it would be a big deal at all.
Thanks so much, Mike. That's Professor Michael Dorf of Cornell Law School. Coming up, Trump's vow to undo Biden's ban on offshore drilling in most federal waters. This is Bloomberg.
President Biden's actions yesterday on offshore drilling, banning offshore drilling, will not stand. I will reverse it immediately. It'll be done immediately. And we will drill, baby, drill. And we're going to be drilling in a lot of other locations. And the energy costs are going to come way down. They'll be brought down to a very low level.
But reversing that ban will be difficult, if not impossible. President Biden is racing to shore up his environmental legacy before Donald Trump takes office. In a last-minute effort to thwart Trump's drill, baby, drill intentions, on Monday, Biden banned all future oil and gas drilling along most of the U.S. coastline, protecting more than 625 million acres of federal waters. Biden used Section 12 of the Outer Continental Shelf Lands Act, which gives presidents broad authority to ban drilling in federal waters and contains no language giving subsequent presidents the authority to revoke those bans. Joining me is environmental law expert Pat Parenteau, a professor at the Vermont Law and Graduate School. Pat, Trump wants to reverse Biden's ban on drilling in those federal waters. Is there authority for him to do that?
So we have one decision on this, and it's a lower court decision from the district court in the Northern District of California. And this district court ruled that the OCSLA does not provide for a subsequent president to revoke a withdrawal from a prior president. So Trump, under that ruling, would not be able to reverse Biden's withdrawal. Only Congress can do that, said this lower court. But again, it's a lower court decision, and people disagree, lawyers disagree, of course, about whether it's binding. Certainly isn't binding beyond, the district court in California. The real question is, is this something that might interest the Supreme Court? Because it does involve a very massive withdrawal of ocean waters from oil and gas development. And, people like Chief Justice Roberts have expressed concerns about the scope of the president's authority under the Antiquities Act, which we've discussed before, to establish these large national monuments, which, of course, Biden has done as well. So it's possible that this is the kind of issue that might find its way to the Supreme Court. Certainly there's going to be litigation over it. Congress is also considering legislation to revoke Biden's withdrawal, and, of course, Congress could do that. It's at narrow margins in both houses, so we have no idea how that's going to sugar off in the end. But right now, my view is Trump does not have the authority to revoke that withdrawal.
He wants to drill, baby, drill in the Arctic National Wildlife Refuge. But the Interior Department has tried twice in 4 years to auction off oil and gas leases there, and there hasn't been a single bidder.
Yeah, the market is flooded, is the answer. We are at record levels of production of oil and gas. So for right now, there's no demand. That could change, but for right now, this isn't the only sale. There was another one on the Alaska coast where there were no bidders, and finally the state of Alaska stepped in and put together a kind of a rough coalition of bidders that, bid on a smaller portion than was offered. So the market is soft, it's flooded, and I don't anticipate that there's actually going to be much demand in the near future for oil and gas. Contrary to the drill, baby, drill mandate, you can't order companies to bid on these things.
So is it contrary to his climate initiatives that the U.S. has become the largest oil and gas producer in history during Biden's term?
You would think that irony wouldn't be lost on at least most people. Seems to be lost on the Trump crowd and the incoming Secretary of Energy, Governor Burgum, who also thinks that we're going to ramp up oil and gas as well as coal development, I guess. But the same thing is true with coal. Now, in other parts of the world, coal is booming, but not in the United States. We're not building new coal plants. It's hard enough to keep the ones running in competition with gas and, in some parts of the country, wind and solar. So I don't know where they think the market is for this drill, baby, drill energy dominance agenda, but we'll find out.
This week, Biden established 2 new national monuments in California to honor Native American tribes. Together, they'll protect more than 848,000 acres of public land from drilling and mining. He's established 10 new national monuments, expanded 2 existing national monuments, and restored 3 more. And the White House says his protection of national monuments has safeguarded nearly 9 million acres of federal lands and waters. Can Trump reverse those?
That's under the Antiquities Act. And the answer so far is no. There is some precedent for redrawing the boundaries of some of these national monuments. Sometimes that's been done by Congress. Sometimes it actually has been done by subsequent administrations. But we haven't seen what Trump is proposing to do, which is either wholesale reduction by, up to, in the case of the Bears Ears Monument in Utah, something like 80% reduction, which would essentially destroy, the designation that Biden and his predecessor Obama had issued, right? So there's no law that says that a subsequent president, in this case Trump, has that kind of authority to reverse what prior presidents have done under the Antiquities Act. But that's one where the Chief Justice Roberts has signaled and interest in at least looking at that question. So, put a pin in it. That's one that could be ticketed for the Supreme Court.
So what happened when, during his first term, Trump shrank the Bears Ears and Grand Escalante national monuments? Was that litigated?
It was litigated. There was never a decision. By the time that it was working its way through the courts, Biden won the 2020 election and, quickly reversed the Trump order revoking the earlier designation. So we never got a ruling on that conflict. The first round, I would say, of litigation over Bears Ears and some of the other monuments. This time around, I suppose there's a greater likelihood of getting some kind of judicial decisions. And then the question is, will it be appealed? Yes. And will the Supreme Court take it? We don't know.
Tell me about Biden's legacy. Is he going to go down as, the best president for protecting the environment?
Boy, it looked that way, didn't it? I mean, if you look at passage of the three big bills, were the initial bipartisan infrastructure bill, to some extent the CHIPS bill, because that's key to some of the clean air energy sources we need. And, of course, the big one was the Inflation Reduction Act. And now I see all kinds of commentary about, it may be that a lot of what Biden did will be time limited. It won't carry forward into the future. Some of what he did will be undone by this Republican Congress, who's expressed all kinds of opposition to what Biden did. Although when you look at the benefits of the Inflation Reduction Act, 80% of the benefits are in Republican districts. So it's kind of hard to really measure what the final impact of what Biden did. My own view is, given, the realities, the political realities of what he was facing, he did an enormous amount. He did do more than any other president. Whether that, turns the tide, so to speak, on climate is certainly an open question. And even if everything he did panned out, it isn't enough. We know that. I mean, the problem that we're facing is so monumental, so overwhelming, that even those major accomplishments pale in comparison to what's actually needed, not only in the United States, but, of course, globally.
Explain the Inflation Reduction Act, which I think is not a great name for this law.
Yeah, it is clearly the most significant climate legislation at the national level that we've seen. In fact, I would say probably it's one of the most significant in the world. It talks about investing $360 billion in renewable energy, wind and solar and electric vehicles and buildings and heat pumps and all kinds of things. A lot of benefits for consumers. Its primary mechanism is tax credits and other kinds of incentives. So it's not a regulatory program at all. It's quite the contrary. It's using the marketplace. And it's designed to leverage even substantially more private capital, and it's doing that. In fact, it's doing it in Republican districts all across the country. It will be interesting to see how the new Congress and the House is going to deal with Trump's promise to freeze all further funding under the Inflation Reduction Act and try to, quote, claw back some of the money that's already been obligated. This is going to come down to some legal questions about how much of the money is Biden able to actually put under contract? In other words, lock it up through legal mechanisms before his time runs out. And I know the administration, from all the accounts, is working feverishly night and day to push as much of that money out the door and get it under legally binding agreements that Trump can't easily repeal or revoke. Of course, with, the Republicans in control of both the House and the Senate by slim majorities. Even so, I expect to see legislation introduced to try to, quote, claw back some of the authorization that hasn't been completely obligated, and maybe even some that has been obligated. Whether the Republicans have the muscle to push all that through both houses is an open question because of the close margins. But I think it's fair to say that the promise of the Inflation Reduction Act to really move the needle on transitions to cleaner energy and transportation is going to be stalled, if not thwarted altogether. And we certainly won't meet the commitments we've made under the Paris Agreement. And of course, Trump will undoubtedly withdraw us from the Paris Agreement once again.
Do you think on this second go round, the Trump administration will be more practiced in how to overturn these regulations in the proper way?
Yeah, their track record in court was one of the worst of any administration in history. They lost 80% of the cases in which they were challenged. You have to believe they'll do better this time, that they'll hire and bring in to the administration really accomplished lawyers, managers, people who know government, know how to get things done in Washington, and that's no small thing. But honestly, given his worst instincts and given his demand that everybody be loyal, do what I want, regardless of whether it's right or wrong, or regardless of what you think about it, my view is they're going to make a lot of big mistakes. Look at what he just said about, I have the authority on day one to reverse Biden's withdrawal of the ocean waters. He doesn't have that authority. He may think he does, but the courts will decide that, right? So if that's what happens, if people are going to have to follow his orders right over the cliff, so to speak, then they're going to repeat the mistakes they made the first time. Our laws, and, to some extent, people who complain about the dense regulatory environment we live with, it's true, it is dense, but it's law. You can't just wave your arms around and make it go away. There are procedures that have to be followed. And yes, there are questions about agency authority under these various statutes. And yes, the Supreme Court has said we will no longer defer to agencies' interpretation of their authority when it's unclear. We'll make that decision. But that's a case-by-case kind of analysis and determination, right? That takes time, more than 4 years, frankly. The average big case anyway, environmental case, can easily take 4 years to work its way through the court system. So this idea that they're going to be able to just turn everything upside down on day one, it's just not going to happen.
Coming up next, how Mexico's president trolled Trump over his promise to change the name of the Gulf of Mexico. This is Bloomberg. President Joe Biden is racing to shore up his environmental legacy before Donald Trump takes office. Just this week, he banned all future oil and gas drilling along most of the U.S. coastline, protecting more than 625 million acres of federal waters. And he established 2 new national monuments in California to honor Native American tribes. Trump has vowed to undo Biden's ban on offshore drilling. He's also called for the repeal of the Inflation Reduction Act, Biden's signature climate law, and he wants to get rid of virtually all of the Biden administration's climate change regulations. But those moves will all face litigation, and litigation takes time. I've been talking to Professor Pat Parenteau of the Vermont Law Graduate School. Pat, how long do these environmental challenges usually take in court? And will the Trump administration be helped by the Supreme Court's rulings cutting back on agency power?
To some extent, people who complain about the dense regulatory environment we live with, it's true, it is dense, but it's law. You can't just wave your arms around and make it go away. There are procedures that have to be followed. And yes, there are questions about agency authority under these various statutes. And yes, the Supreme Court has said we will no longer defer to agencies' interpretation of their authority when it's unclear. We'll make that decision. But that's a case-by-case kind of analysis and determination, right? That takes time, more than 4 years, frankly. The average big case anyway, environmental case, can easily take 4 years to work its way through the court system. So this idea that they're going to be able to just turn everything upside down on day one, it's just not going to happen.
And when the Trump administration wants to undo a Biden rule, will they have to go through the formal notice and comment rulemaking process to repeal and rewrite the Biden regulations?
In Trump 1, EPA and several other agencies, Interior Department, failed to follow the requirements of the Administrative Procedure Act and found that they lost about 80-some% of the cases in which they were challenged. This time around, they may be smarter about that. You'd probably think they would be smarter, but if they're in a hurry, if they're in a rush to show progress on this deregulatory program, they're probably going to be cutting some corners and skipping some steps that are required by law including notice and comment. And, the environmental community is geared and ready to go. They know the playbook, and they're beefing up their staffs. They're hiring more lawyers. They're going to be doing more fundraising. The Sierra Club alone filed over 400 lawsuits against Trump attempts to roll back rules. When you think about Earth Justice, the Natural Resources Defense Council, and many other major environmental groups, they are going to be challenging Trump's and Administrator Zeldin's attempts to repeal and revoke these rules. It remains to be seen how that's going to all play out in court. We know there are a lot of Trump judges on the federal bench, but there's still going to be dozens of vacancies on the federal bench and maybe more over the 4 years of the next Trump administration. So, the prospect for how these attempts to deregulate are going to play out in court, it's an open question right now. Lots of litigation for sure, wins and losses both ways for sure. But, Trump can't do this with the snap of a finger. A lot of it is going to have to go through court before it's resolved.
I want to touch on the Endangered Species Act. The Biden administration had restored some protections that the first Trump administration had rolled back, and there's been a flurry of last-minute activity on endangered species by the Biden administration, including keeping the grizzly bear as a threatened species through much of the western United States. Do you think the second Trump administration will take aim at the Endangered Species Act again?
Yeah, I think the Endangered Species Act is in serious trouble. That's a law that I, have been involved with for literally 50 years. And I litigated some of the early cases under the act. So both in Congress, and through the administration, I think the act is in serious trouble. Even though it's highly popular with the public, at least when you poll the public on do they want to see strong protections for endangered species, there's a very high percentage, sometimes 80 or even 90% public, support for protecting endangered species and their habitat. But, anytime that interferes with other commodity uses, whether it's oil and gas or mining for copper or other valuable minerals or grazing or any other major economic interest, it's going to lose out. It's one of those laws because it's trying to protect the entire sort of spectrum of species all the way down to plants and insects. And of course, when you think of insects, you think, well, why are we protecting insects? But when you think about pollinators, that's one good reason why we protect insects. They're a keystone species for a lot of food crops. And you could go down the list. There's lots of reasons, economic reasons, why protecting species makes sense and why protecting their habitat is really another way of protecting the communities that live within these areas and helping with climate resilience and dealing with floods and storms and droughts and wildfires and all the rest of that. The healthier your ecosystem, the better able you are to withstand some of the impacts from climate change. So all of this now is going to be debated and argued, but it sure seems clear. And, protection for species, which has been not working out very well. I mean, we're still losing an awful lot of habitat every year necessary for protecting these species. It looks like that trend line is also going to be in the negative as well. States, again, can step up if they're willing to and do a lot more of this land conservation work. But, they're also under a lot of political stress from their constituents to open up public lands for even further extraction and development. So right now, it's a pretty hazy picture, I would say, for the future of a lot of these species that are really just clinging to existence and rely on government efforts to turn the trend of extinction around into a more positive direction.
We talked about how Trump's promise at his press conference on Monday to reverse Biden's sweeping ban on oil and natural gas drilling in U.S. coastal waters immediately won't happen immediately and may not happen at all. Listen to what else he promised at that press conference.
A future date, pretty soon we're going to change because we do most of the work there and it's ours. We're going to be changing sort of the opposite of Biden, where he's closing everything up, essentially getting rid of $50 to $60 trillion worth of assets. We're going to be changing the name of the Gulf of Mexico to the Gulf of America, which has a beautiful ring that covers a lot of territory. The Gulf of America, what a beautiful name. And it's appropriate. It's appropriate.
Well, Mexico's president, Claudia Sheinbaum, responded sarcastically to Trump's proposal to change the name of the Gulf of Mexico at her daily press briefing.
Obviamente, el Golfo de México es reconocido el nombre por Naciones Unidas, un organismo de Naciones Unidas, pero el siguiente, ¿por qué no le llamamos América Mexicana? Se oye bonito, ¿no?
So, standing before a global map, she proposed that North America be renamed America Mexicana, or Mexican America, because a founding document dating from 1814 that preceded Mexico's Constitution referred to it that way. That sounds nice. No, she added. Pat, I have to say that this Trump suggestion bewildered me. It's been called the Gulf of Mexico for at least 400 years. Who has the power to rename a body of water that touches several countries?
Right. There is no central authority for that, not globally or internationally, and not even domestically. There is an Office of Mapping and Cartography in the Department of Interior, which keeps track of the names of various water bodies all over the world. And there are disputes about, for example, whether it's the Persian Gulf or the Arabian Gulf. And this office actually sometimes maintains dual names of water bodies. But there's no one authority to say, yes, we can change the name of the Gulf of Mexico to the Gulf of America. I mean, maybe Trump will issue some kind of order declaring that. Will it have any legal authority? No. Will it make any difference? No. Will it reduce the price of eggs? No. It's a waste of time.
It may be a waste of time, but Representative Marjorie Taylor Greene, Republican of Georgia, said that she plans to introduce legislation to change the name of the Gulf of Mexico through an act of Congress. She wrote on X, "I've directed my staff to immediately begin drafting legislation to change the name of the Gulf of Mexico to the Gulf of America. This is important to begin funding the changing of maps for all agencies within the federal government, like the Federal Aviation Administration and the military." So more to come on this. Thanks so much, Pat. It's always a pleasure. That's Professor Pat Parenteau of the Vermont Law and Graduate School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.